And please the court, Janine Jeffrey on behalf of Officer Lockwood, currently serving officer of the Los Angeles Police Department. I'd like to reserve 2 minutes, please.
You may. I'll try to help you watch the clock.
Thank you, Your Honor. On this appeal, we're asking this court to reverse the district court's decision not to give Officer Lockwood qualified immunity. And I think on both grounds in the qualified immunity world, that there was no clearly established law. And I think even under the undisputed facts of this case, this officer should be entitled to qualified immunity. I'll try to stay closer. One of the things I want to point out that I think is missed in some of these qualified immunity analyses is that the purpose of qualified immunity is to protect all but the incompetent or those who knowingly violate the law. The problem I have with some of these cases is that the Supreme Court has said what we want to do is we want to encourage officers to do their job. We know people will make mistakes. That's what they said in Rhodes versus Shore. And I think it's important to start that with the basis of what we're doing here. And in that case from 1974, the court said, implicit in the idea that officials have some immunity, absolute or qualified, for their acts is the recognition that they may err. The concept of immunity assumes this and goes on to assume that it is better to risk some error and possible injury from such error than not to decide or act at all. And the reason it's so important in this case is we have a situation where there is a pursuit and Officer Lockwood sees a suspect. He believes the suspect has a gun. That suspect goes headlong into an apartment building. Officer Lockwood chases him. Now, at some point along that way, Officer Lockwood believes that the suspect is turning. Now, if the court doesn't give qualified immunity in a case like this, isn't the message, and maybe much like the traffic case that you had earlier, isn't the message that they shouldn't chase the bad guy? And I mean that with all respect to Mr. Edmond. I mean, he's a felon in possession with a gun, right? So the officer says he sees what's going on, he sees the gun, and he chases him. If this court decides that Officer Lockwood is not entitled to protection under those circumstances, I think that flies in the face of the point of qualified immunity, which is
the turning point, if you will, in this chase when Mr. Edmond does this turn.
I think yes and no. The turning point, because you have to look at it from the reasonable perspective, from the officer's perspective. So I understand there's a dispute about whether he was turning. I say he started to turn. The plaintiff says he's not turning. But I don't think that should carry the day.
Okay, let's say there is no turn. Chasing the suspect, we now know, actually these videos are not fantastic, as you know, but it looks like there's a Dempsey dumpster or something there at the end of the hallway. He's just chasing him down this, we'll call it a corridor. If there's no turn and he's just chasing him, up to that point, is there any basis to fire?
Well, here's the issue.
I'm just asking you, what would be your answer if we could just wipe out this turn issue? Just to start, and then we'll get back to the turn.
Can I ask one clarification? Is the hallway at an end, or can he keep going?
What does the officer know or believe?
I believe,
based on what we have in the case here.
I'm not sure that's in the record, in fairness. I don't think it is. Exactly, which is, I think, another factor that has to be taken into account for this officer, because we're not talking about an officer who's gone out to to go and get somebody. He's doing his job. He's chasing the suspect. He thinks it's his perspective, and we can all look at that video till the cows come home. We're all going to disagree about it.
But he says that the concern was this kind of furtive movement, kind of this gesture. That's what the officer pins this on, right?
The actual shot, yes.
Okay.
Yes, I think that's a fair statement, and I think you don't need a furtive movement under the case law to qualify as a act within the Fourth Amendment. Because if we look at Casella, which is the Supreme Court case where the woman had the knife, now she was standing within 6 feet of, turned out to be her roommate, but the officers didn't know that. She didn't make any furtive movements, and that was deemed to be qualified immunity. The other case, the case that the Supreme Court relied on was Blandford, and that is 406 F. 3rd 1110 in 2005. That's the case where the guy is, I don't know, running around town is the right phrase, but he had a Civil War sword, 2 to 3 feet. He didn't make a furtive movement. The issue was the concern for the safety of other people. And that's the problem here. So our officer also has a concern that this guy's got a gun and he's running into an inhabited apartment complex.
Do we know from the record if he's left-handed or right-handed?
I do not know that. I don't know that.
I think the officer identified a gun on the left side, correct?
Correct.
From the bulge.
Correct.
But counsel, let me get back to Judge McEwen's question, because it seems to me there has to be some movement by him. He can't just shoot a guy in the back, and there are lots of cases saying that. So for you to win this case, you have to show us it's undisputed that the plaintiff here made some move. If you're saying that if you can't go that far, then I think you got a tough case.
But I'm not allowed to ask you, but under
Casella question, we might have.
I'll rephrase the question. Is there a case you know of that says that officers can shoot a fleeing suspect who's not displaying a weapon in the back?
Who's not displaying a weapon?
Not displaying a weapon.
But the officer thought he was displaying a weapon.
No, but that gets the whole move question. That's what I'm saying. We need to be clear. What's disputed and what's undisputed in this case? If it's undisputed that the guy was simply running away from the officer, even if the officer thought he might have a gun in his possession, we have all kinds of cases in this circuit that say you can't shoot someone in those circumstances. The question then is that if he was making a move, that's what Judge McEwen was asking. If he was making a move, different story. Is it undisputed about whether he was making a move or not?
It's not undisputed, but my problem is that it's supposed to be from the officer's perspective. He's running down a bad guy at night in an area that's known for gangs. So we're going to hold him to...
Wasn't it undisputed that he did turn right and that the shooting occurred right after that happened?
That part is undisputed. What the plaintiff is saying...
When he turns right, I mean, that exposes his body and his hands to the officer.
Yes. I think that's true. And I think we have to look at this. I mean, that's a scary thing, right?
My point, isn't that enough?
I think it is enough.
That's what I'm trying to get from you. Okay, what I'm trying to get from you here is simply a guy's running away, you can't shoot him in the back. If he makes a move of some kind that indicates he may be turning to shoot, that's a different story. So tell us, what is the undisputed fact that opposing counsel cannot, logically disagree with, that shows that he made some movement, the plaintiff made some movement that the officer here would have reasonably thought, hey, he's going to draw on me, I got to do something. Can you point us, is there deposition testimony? Is it the video that's undisputed on that fact?
Well, we have video testimony, the video deposition. I'm sorry, let me try it again.
You're talking about the body camera.
Correct.
So you're saying the body camera is undisputed, that during the chase, the plaintiff made a move towards the officer that would make the officer think he's going to fire on me.
Yes,
So
and
you're
I'm
saying
saying
that's
a little bit more than that.
Okay, and you're saying, again, undisputed, because that's jurisdictionally, that's what we're at here.
Does it become undisputed if lawyers don't argue about it, since we argue about everything?
So the counsel, again,
I mean, in fairness.
I mean, I know, but let's not talk in riddles here. Let's talk what the undisputed facts are. The undisputed facts here, just walk me through, because for you to win this case, you need to show us how the undisputed facts mean you win. So walk me through that.
Okay, I'm going to give you all the undisputed facts.
Okay.
It's nighttime. My officer knows he's in a gang-related area. The suspect sees the officers. My officer, first officer, the actual defendant officer, Lockwood, believes he sees a gun. The officer behind Officer Lockwood calls in independently on his radio and says, "Man with a gun." It's undisputed. Edmund is told to stop, put his hands up. It's undisputed that he ignores that and he runs into an apartment complex. It's further undisputed.
Turns into the apartment complex.
Correct. Well,
No,
he's kind of
he's
right
in
in
a
front of it.
So up to now, just, we take all your facts. We have these cases that say, Peck v. Montoya, that if he is armed but not reaching for the gun, you can't shoot him. So right now, where we have him, we haven't gotten to the turn. We have an armed suspect who's fleeing, but no evidence of reaching for a gun yet, right?
That's correct. But
Okay, now what happens?
can I say one thing about Peck?
Sure.
Peck is in 2022 and this occurred in 2019. So my officer can only look theoretically at what the case law is in 2019. And I would again submit that there isn't any clearly established law that fits these kinds of specific Fourth Amendment facts.
So you're saying there's no clearly established law before Peck that you can't shoot a suspect in the back if they're not reaching for a gun or threatening you?
But I don't think you can narrow it that much. I think you have to.
Yeah, we have to, because sometimes we have people who are fleeing. They've got a gun, we think they have a gun, but they're not actually threatening the officer. Now, I'm not saying this is what's happening with your suspect, but that's what our law has long been. And as Judge Owen says, I think you need something more. You need some threat or movement that would cause the officer to have reasonable belief now the officer is threatened.
But see, this is where I get stopped. The officer perceives the threat. The officer is chasing this guy who's not listening to his commands to get down.
When he's chasing the guy, is he perceived as a threat to the officer? Are you really saying that?
A man with a gun who's running away, I think, is fairly perceived as a threat to the public at large. And that goes back to how I started this argument. If the Supreme Court in Shore v. Rhodes is saying we want to give the benefit of the doubt to the officer because they're going to err. This is about mistakes. And I think
thought you would have said that we went down this corridor. We don't know that there's a Dempsey dumpster there till we can see the video. But then he turned.
Right.
And when he turns, the officer now thinks, he's going for the gun. And that's why I asked you, do we know if he's a left or right-handed guy? Maybe it's not in the record. But you're actually telling us that we should make this decision before the turn?
I think you can. I think there is a turn, but obviously counsel is going to argue that there isn't a turn, and I don't think that should carry the day. That's my argument. And the reason it shouldn't carry the day is because the point is we want officers to do their jobs with vigor. And if we're going to hold them responsible for mistakes, at worst, this was a mistake. He maybe thought he was turning. He did think he was turning, and maybe he's wrong by the video. I don't know. I wasn't there. It's a really fast, quick evolving situation. And he's got to make a decision like that. My life or his. If he's not turning, he gets sued. If he's turning and he's wrong, he's possibly dead. And I think under the Supreme Court's decision in Shore versus Rhodes, which is basically saying, look, this is why we have immunity, because people are going to make errors. And we don't want to make them go through the whole trial because that defeats the purpose of immunity. So I'm saying a little bit more, I'm talking to you more on a policy level than the specific facts Was he turning? I say my officer thought he was. I'm going to be out of time momentarily, so I'm going to reserve my 26 seconds. Thank you.
Afternoon. So we begin with the concept of this is a bad guy. I heard counsel just say that. There is no evidence that Officer Lockwood had that any crime had occurred whatsoever in this area. There is no evidence that he had whatsoever that Mr. Edmond had committed any crime whatsoever. He was at this gathering, which was in the wake of a funeral. This is not a criminal activity. He sees Mr. Edmond starts running. He has no idea that Mr. Edmond happens to be a felon. He has no idea that Mr. Edmond may be running for the purpose of getting rid of this firearm. His focus appears to have begun after Mr. Edmond started running. So we don't have, the first factor in Graham is what is the crime at issue? We don't have a crime at issue. We don't have any knowledge of a crime at issue. We have a man who sees...
Prior to the shooting, the other officer declared a man with a gun running.
He said, we are following a man who may be armed.
No, he said man with a gun.
Man with a gun?
I'm pretty sure something close to that.
So in terms of what he said, does that mean that a reasonable officer in Officer Lockwood's position would have similarly concluded that? Because
Well, I thought they were potentially concluding that because of this bulge that they're seeing, and they're pretty sophisticated about the difference between having a lot of money in your pocket versus a gun. So why wouldn't that be a reasonable interpretation?
Well, the issue of the bulge is very interesting, Your Honor, because I don't think that anyone that was involved in this foot pursuit, and I do stand corrected, Your Honor, because you were right. It just came to me. Forgive me. I don't think that anyone is going to say that he was doing anything with that bulge or that he had it in his hand.
I agree with, at this point, all we have is man with bulge, believed to be gun, called in as a gun, in a high crime area, correct? And he's fleeing.
And what is the high crime area and the gang area? He's fleeing. We can't shoot a person for fleeing. The concept of this party being in this park is something that is very significant because there have been many assumptions that have been made by this officer just based on where this park is. If the park had been on the west side, for example, where it's not a gang neighborhood and it's not known to be a gang neighborhood, would his calculus of reasoning have been different? Would Mr. Edmond have less of a chance of being shot at? And the idea that he happens to have a party and he happens to be in this particular area, it's a gang area, but I asked this man, this Officer Lockwood, several times, did you see anybody you knew to be a gang member? No. Did you see anyone that you recognized as having gang attire? No. Did you see anything that would place this as a gang? No, but it's something about just this location that he's focused on. The second thing I asked him is,
I don't agree with that, but the point is, the problem is that by the time of the shooting, your client fled, and the officers reasonably, I think, everyone would conclude, reasonably believe that he had a gun, and so therefore that's a pretty strong basis to believe that there was a crime being committed, and a dangerous crime.
well, I would ask what crime would that be? If the officer
Well, this
doesn't
is California. It's very rare that people are allowed to carry guns.
That is true, but it's also not a probable cause. Well, it's just the presence of a gun, and as Judge Owens has repeatedly pointed out, that's not enough just having a gun. But when you think about the fact...
So let's get to that. The actual point that matters is, like, did he turn or not? Is that disputed? And to me, I've watched the video dozens of times, and it's undisputed that he turns right to go into an alleyway, right? And and that would expose his hands closer to the officers, and this is split-second timing. Why is that turn not enough to threaten the officer?
Because it happens way before the shooting. Are you
But
talking about?
instantaneously.
You're talking about when he?
Yeah, makes the right into the
He's gone
alleyway.
with that on the
Okay.
video.
Because at that point, his hands look pretty, exposed and dangerous.
Well, when we think about what led up to the turn, and when we think about the turn itself, is he turning to go to a different part of the apartment complex?
it's clear he is.
Or is he turning it in such a way as to threaten somebody with some
Right,
kind of
that's
firearm?
the question.
Question.
And I think that because you're telling me that's the question, that is the question.
Right.
It's a disputed issue of fact as to what he's doing, because we really
But why
can't
isn't the
conclude.
turn enough to trigger something in the officer that he might be in danger? Because as you admit, turning to your right could either mean he's turning to go down the alleyway, or it could mean he's turning to start shooting.
He has to at least see something that's going to trigger him possessing that weapon associated with that turn. It can't just be the turn in isolation. It has to be something that would cause a reasonable police officer to believe that that turn is going to threaten his life somehow.
And you think that, and it's disputed what's in his hands. I mean, in my view, I don't think it matters, but when he turns, I see a black object in his hand, in his left hand.
First of all, your view matters a lot, okay? I gotta put that
He
out
needs
there.
two. He needs two, not just one on this point. Go ahead.
One gun, two people.
Yeah, now, we don't see anything at all in his hands, and I think if you play that video in slow motion, you're gonna see that object fall down. And it's suspended in air. When we hear the fourth shot, you can hear the shots coming quickly, but that gun is clearly not in anybody's hand at all when you hear the fourth shot, so.
I agree with that.
Yeah.
And Your Honor,
But I think what your colleague was pushing was, did the officer have to wait for that gun to come out and be aimed at him before he made the split-second decision that he was at risk? So that's kind of this hair splitting that we're engaging in. Is
Right.
She's arguing, well, the reasonable officer is now informed. And you're saying, why?
well, in principle, he wouldn't have to wait if a reasonable officer would have seen this gun in his hand. But all he knows, folks, and this is why this case is so distinguishable from so many of your cases, there's no crime here. He doesn't know anything at all about this man. And he's following him only because he ran. And that is the only probable cause. That's the only thing that even alerts him to this young man's presence, is that he ran. Now, a person that is a complete neutral factor, a person that has not committed a crime, who's not wanted for a crime, they're not on the lookout for him, he's just a guy at a party or at a gathering in the wake of a funeral. Under these circumstances, the idea of him reasonably believing that this man is holding a gun and turning towards him that's not gonna cut in the government's favor, because there's no crime at issue that would bring this to halt. Now, as the court is well aware, in this circumstance where he is holding a gun and he is turning and shooting, I lose that every time. He's turning, even if he doesn't shoot or anything, I lose that every single time, because we cannot allow that. If it's that close, it's gonna always cut in the government's favor.
So here, is it that there's a factual issue as to whether the gun was in his hand? Or does a reasonable police officer's view that there seemed to be a gun in his hand win the day?
I don't know if they're distinguishable. And those two scenarios, I think we definitely have a factual issue. I don't think the video shows him touching anything resembling a gun. I don't think, and it's also in terms of the four shots that are being fired, some consideration should be given to the fact that every round can kill. Every single time he presses off a round, that round has the power to take a life. And if we look at all of these rounds, I believe the facts are completely undisputed that he's firing at least that last one when it is clear. Not only is Mr. Edmund falling to the ground, but this firearm is separated from his person. Now, would a reasonable officer have done that? Have fired so many rounds?
Officers trained to do that. When you're firing one bullet, you're fighting to kill, and you're not there to train and try and do a trick shot and knock the gun out of his hand, right? And
I I don't think they're trained to kill. I think they're trained is to, quote, stop the threat, end quote. And the threat in this case would have ostensibly been from this person with a gun turning towards him. But if you just look at the geometry of this, how is he going to get around all of the way to do this? And the reason why I'm saying that we're splitting hairs here, this is not a situation where the police were called out on a man with a gun call, or that this is a situation where there was some predicate factor that would give them a reason to believe that this man posed a threat. He had not committed a crime, and I can't stress that enough. Presence in a gang neighborhood is a geographical mistake that should not have made him more likely to get shot by a police officer. And I don't think anyone should say anything differently. He's not a gang member in the eyes of this particular officer because he doesn't see anything associating him with that. So to say that he's a bad guy presupposes facts that the officer doesn't know. And in terms of this critical moment that everyone's fixated on, which should be, everyone should be fixated on it, there's so many different ways you can look at this. And there's so many different ways you can look at Mr. Edmonds' behavior. And you have to take into consideration that he is holding his hands up at several points during this foot pursuit. And when an officer is saying...
I agree with that. The problem is, there's also times where he's going like this.
Well, he's going around the corner. The officer is saying to him, let me see your fucking hands. Well, he's screaming it out. Get on the ground, I'm going to shoot you. Now, if you take into consideration those words stated loudly, while he's got a gun in hand, while he's running, it's reasonable for this officer to conclude that my words might make this person think I'm going to shoot him no matter what he does. Because he's yelling at him in a manner that is, you hear that tape, it's loud, and the person on the receiving end of those commands is doing this while he's running. And it's not stopping, he's looking behind himself, but that's not stopping
Are his hands up when we get that, either stop or I'm gonna effing shoot you?
Yes, during that period, yeah. He's running with his hands up. Now, it's quick.
But it's pretty uncontested afterwards. His hands drop down to his waist level, where a gun would be concealed.
I wouldn't say that. I would say they drop out of view, but I wouldn't say they drop down to his waist. He's turning the corner. He's going to get shot pretty soon after he rounds that corner.
Great.
So at that point, he's in the process of how does a reasonable person get shot and fall down? He's hit and he's going to the ground.
That's the problem I have. It's that turn, can be categorized as innocent, like trying to make a right turn, but turning could also be a threat, right? He's not like running straight down a hallway with no chance of, turning around. He's turning and making a movement that could be threatening.
Well, Your Honor, while his state of mind is not dispositive, you're absolutely right. But the fact that we are splitting hairs and talking about whether he's doing this or whether he's doing that or what is, I think he was running for his life trying not to get shot.
Remind me in the video, we've got after the fact photos, which are quite clear of that dumpster thing. So it looks like you would run smack into a dumpster if you didn't turn.
Mm-hmm.
Can you see that dumpster at night based on the video?
Great point. That's a great point, Your Honor. And I don't think that I could make I don't know. But what we know is that is he turning, would a reasonable officer conclude he's turning simply to continue his escape or continue his flight, or is he turning to show a gun? I think that we're always going to have genuine issues here. And as this court has repeatedly said, in a shooting case such as this, if there are reasonable interpretations, the government's not going to be able to prevail and take it away from the jury on qualified immunity. And I think that's always going to be where we get back to. What was he doing when he turned that corner? We don't know.
My counter would be that in these situations, isn't that precisely why we have qualified immunity, that so officers don't have to make this choice between their life?
If the situation is that way, but if there are factual disputes as to whether or not a reasonable officer would be in that position, I think that we aren't allowed to just establish as a matter of law qualified immunity. And the factual disputes is why we're here today.
But I guess I just don't see this dispute that he had a gun and the officers believe he had a gun and he made a turn.
If that is enough, then what that would mean is that if any time an officer was running after someone and they turned, that would be enough to shoot him. I think that you have to have something that a reasonable officer would interpret as him holding the gun and doing something with that gun that a reasonable officer would deem threatening. I'm out of time. I'd love to talk if you want to keep hearing.
I did have one follow-up question for you. So as I remember the video, they run down the hallway and then he does turn right. And it is, I think, undisputed that he makes the right turn. What I was asking, all the questions I was asking about turning was, did he make a second turn, which then led to the shots, like a second movement like this? And you're saying that is clearly disputed, the second turn.
Yes, and it's also, and I'm glad you brought that up, Your Honor. There is a hail of gunfire happening instantaneously after he turns that corner. So when he's being subjected to gunfire, his body is in the process of, one, being shot and two, falling to the ground. And a reasonable officer must conclude under those circumstances, perhaps his body is moving in response to my rounds hitting him, and not necessarily independently. He never has a gun in his hand from what anyone can see. Thank you.
Can we put 2 minutes on the clock, please? Thank you.
Thank you. I just want to clarify a couple of things. First of all, counsel conceded all along that there was reasonable cause to stop his client. We also have the Heck versus Humphrey issue where he pled guilty to felon in possession of a gun. So he can't turn around and say, well, there wasn't reasonable cause to stop him, because that would undercut the conviction for being a felon in possession of a gun. So all of that issue, I think, is moot, a red herring, as we say.
Well, and they don't know he's a felon in possession as they're chasing him.
No, but they do know
But he has a gun.
He has a gun.
Right,
I
so
mean,
then I think counsel's question is, what was his crime at that point?
but he doesn't have to have a crime at that point if they have reasonable cause to stop him and he runs. If you have reasonable cause to stop someone, they can't just take off running. That's not the way it works. What's a little frustrating here is, had he just stopped, and Mr. Edmond just stopped, this wouldn't have happened. And we put everybody in this dangerous situation where this officer has to potentially risk his life to save the public from what he perceives to be a man with a gun running into an apartment
But
complex.
this day and age, sort of saying if he stopped, nothing would have happened. Kind of a risky proposition for
Well,
the individual, isn't it?
That's a little unfair, I think.
No, I mean, but from a reasonable person's point of view in this situation.
And
Counsel, if I could just jump in real quick. I thought the best part of your brief was pages 20 through 22, where you have the photos. Okay, do you remember that?
I do.
We haven't really talked about that. That's where I was kind of going with you earlier. I thought you might want to
It
point
was
us
a
to photos.
softball.
And you haven't. In your brief, you argued that the photos show beyond dispute that the plaintiff turned before the shots were fired. Correct? Isn't that what your
Yes.
photos were saying?
Yes.
Okay, so when I was asking you before about undisputed facts, you didn't refer to any of these photos.
And I apologize, I guess because I feel so strongly that in this situation.
I understand that, but my questions were what were undisputed. And so are you backing away from the photos? Or are you saying when I asked you those questions 20 minutes ago that you should have pointed us to the photos then, and then we'd be done?
The latter,
Okay, so now you're saying that.
correct.
Just want to make sure I understand. Okay, thank you.
Good answer.
While you're at,
Can I just, I have a couple more points. I think you don't have to have the gun in your hand, because in Cruz, he didn't have the gun in his hand, and the court was pretty clear that said, if he's reaching for his waistband, there's qualified immunity. If he's not, then there isn't. So I don't think there's a criteria here that you have a gun in your hand. The weapon has to be in your hand. And I tried to point out under Casella and Blanford, while I believe there is a furtive movement, yes, I believe there's a turn. You don't have to have the turn. Under either of those cases, there was no turn. There was no furtive movement. And I think those are critical facts that I asked the court to at least take into consideration in making this analysis. And I thank you for your time and patience.
thank you. Thank both counsel for their arguments and also for the briefing. case just argued of Edmund versus Lockwood is submitted.